If you're interested in how Tiny and T.I. won $71 million in a trademark infringement action against the LOL surprise doll makers MGA Entertainment, listen up. For the legal nerds out there, this case has so many interesting twists and turns, particularly for it to be trademark infringement. You'll enjoy this. So before winning this $71 million, this case harkens back to early 2023 and before. When Tiny saw that LOL Surprise Dolls had dolls that looked like the OMG girls, in fact, the original name of the dolls were LOL Surprise OMG, Tiny reached out to the doll maker and said, hey, I need you to stop using our likeness and image, but let's come to the table and talk about it a little bit and see if maybe we can enter in some type of business deal. Sending a cease and desist letter is an intellectual property owner's duty from the beginning to put the other side on notice that you are infringing on our rights. But not everybody reaches out and said, but that's okay. Let's see if we can work together. Well, the toy maker, instead of responding to the cease and desist letter, simply filed litigation in federal court in California, asking the court to make a declaratory judgment that they are not in any way infringing on the OMG girls. Now that was a sharp move. So of course T.I. and Tiny, they got to go to court anyway, and so they filed a counterclaim. And their counterclaim was for obviously copyright and trademark infringement on the likeness of their OMG Girls group and their members. Now understand, prior to this litigation, OMG Girls did not have the proper trademark and likeness registration for their brand. But one was filed prior to this litigation actually beginning, because the starting process to litigation usually takes a little while. Well, that first case resulted in a mistrial back in January of 2023. It was a mistrial because evidence that had previously been excluded was allowed before the jurors. There was evidence by T.I. and Tiny's lawyer that there was some type of racial appropriation by the LOL Surprise Dolls and their design like their members. And the court said, the jury wasn't supposed to hear anything about that. The case was declared a mistrial. So the case comes back to trial again for LOL Surprise Dolls to have a declaratory judgment entered that there is not infringement occurring. In a declaratory judgment case, the person is usually not seeking money or any action other than a court looking at the facts of the case and deciding there's no infringement, and it deads the issue forever. Well, MGA Entertainment, the LOL Surprise Doll owners, won that case, and T.I. and Tiny did not win any money. But that was not the end. Right after their trial ended, almost immediately after, the United States Supreme Court made a ruling in a Jack Daniels case that has now become very important case law as it relates to trademarks. I have a whole explanation of that Jack Daniels case, but here's a quick summary. Jack Daniels sued a toy maker, a dog toy maker, because they had a dog toy called Bad Spaniels that looked like the Jack Daniels bottle. Jack Daniels sued both because of the name Bad Spaniels, which was similar to Jack Daniels, and because of the design of the bottle, and they won. The dog toy company said, nobody would confuse our products. We're dog toys. They're alcohol. No big deal. It's just a parody. The Supreme Court did not agree. So the LOL Surprise Doll Company couldn't later claim that these dolls were just a parody of the OMG Girls as an excuse as to why they should get declaratory judgment. And because of that and a couple of other legal reasons, that case was overturned and they had a third trial. In this trial, the third trial, T.I. and Tiny won $71 million based on trademark infringement. Out of about 30 dolls that were presented as infringing items, the jury found that somewhere between 8 and 12 of them were actually infringing, and they received both actual damages and punitive damages for the infringing action. The punitive damages were about $50 million of the $71 million win. In trademark litigation, punitive damages can be triple. We call them treble damages. And it's triple because it's going to be 3 times as expensive as the actual loss for the damages, because it was intentional. It was purposeful. The jury found that not only was this infringement intentional, but all of the actions of MGA from there were inappropriate and exceeded the needs for litigation, and therefore they had to pay up. So congratulations to T.I. and Tiny, but I don't think this case is over. For $71 million, it's worth the effort to go ahead and appeal this case for years and years to see if you can win. Those lawyers' fees will be a little bit less. Watch the playlist for other information about when this case first happened. Give me a like and a follow.